I'm sorry, my lords, maybe trouble your lordship for a minute. These are matters which are pertaining to court hall number 7, my lords. In charge is given to court hall number 4. We moved the matter and we were directed to move your lordships, my lords, because the court hall number 4 informed that they have no power to take memos. Matter tomorrow is the examination of the guested probationers. All connected matters, my lords, in which interim order is granted, permitting them to write the examination. We are only seeking for a permission to write the examination, my lords. Court hall number 4, my lords, informed us to move your lordships, my lords. Tomorrow is the examination, my lords. Lordships consideration.
Sir, belongs to which court?
Court hall number 7, my lords. It's a service administrative tribunal matter against the order of the administrative tribunal.
Go to number 7.
Court hall number 7, my lords, is not sitting today, my lords.
Not sitting.
Not sitting. Honorable
Go to drop bench.
Well, it's in charge bench. We went before the in charge bench. We were directed, which is court hall number 4. We were directed to move your lordships, my lord, since they have no power to take up the memos, is what we were informed, my lord.
It will go to drop bench. Register judicial.
But the matter is tomorrow. Since the examination is tomorrow,
so it will go to mention with drop bench. The next bench where normally.
The next bench we mentioned at 10:30, my lords.
Which bench?
Court hall number 4. My lords, and we were directed to move your lordships, my lords, since the matters cannot be taken up before court hall number 4. Therefore, we are before your lord.
Why? You tell the.
My lords, we informed, my lords. We informed that court hall 7 is not sitting. Therefore, your lordships have the roster. My lords.
Wait.
Yes.
Yes.
Same matters. Can we just pass on the memo so that your lordships? Very well.
One matter, my lords. Lordship had reserved this matter on last Monday regarding late encroachment with the liberty to file written submissions today. I'm filing my written submissions here.
Lake
Encroachment matter which was resolved last Monday.
Give copy to others.
Lordships.
He didn't tell me anything. Something.
It's a fresh matter.
It's a fresh matter.
If somebody moves a fresh matter before the court, it is not a. For me, there is no, it is already assigned. The boards have been assigned. There is nothing to be on. There is no question of doing anything in judicial side, and nothing can be on the administrative side because already done. We already mastered the roster. We already mastered the roster. just go back and I'll not say anything. I can't say anything on judicial side. Discretion of the court where which is to be taken up. But you mentioned it. You're saying you go fast and mention. And tell the court that we mentioned the before the first court, but court said no, it is not our domain of your lordship.
Lordship kindly.
You tell the court that this is not our domain of the first court, but my lord's domain.
Kind, my lord, this is a fresh matter, my lord, where the employee who was, my lord, already subjected to, my lord, the inquiry proceedings after his retirement, my lord, he is given a clean chit. After that, my lord, on the same set of cause of action, my lord, the second inquiry is initiated, which was brought to the notice of the honorable single judge. Now, my lord, without even paying my pension and other consequential benefits, my lord. Now, the honorable single judge, my lord, during the course of the challenge to the second inquiry proceedings on the same set of cause of action, on the same set of charges, Lord has directed the bank to, my lord, to conclude the inquiry within a period of 1 month. And, my lord, on the same set already, my lord, there is an order of inquiry where I have been ordered to be compulsorily retired also. And now, my lord, in view of this direction that the inquiry, second inquiry to be concluded within 1 month, my lord, now I have been asked to appear even in the second inquiry on the same set of charges where I was, my lord, ordered to be compulsorily retired. My lord, I may be given the liberty to move the vacation court so that, my lord,
It is always there.
no, my lord, what happens, my lord, it is filed prior to the vacation, my lord. It was filed 4 days earlier, my lord, the writ appeal. So now-
No, even then you can move.
My lord, last week your lordship said direct.
It is not listed before this.
If my lords would pass in order that, my lord, I am at liberty to, my lord, move. The other day, my lord said,
We passed in 2 cases, but then it was finally ascertained that even the matters which are not filed during vacation, but filed prior, and there is an urgency, you can mention and get it listed.
my lord, the earlier when we had moved, my lord said ordered it after vacation. We had moved it on the next day of filing also. First memo when we had moved, my lord said, my lord, immediately after vacation, my lord said passed an order. Subsequently, I received a notice to appear in the second.
That's a good ground to convince learners to vacation. Subsequently, you received the notice. He will not trench upon our own jurisdiction, nor will trench upon the jurisdiction of the other courts. You are not remedial. As you go, it will be circulated. So you can file IA, you can mention the court, right? You can IA in a vacation and get it circulated. IA.
Right. Very well.
We are not to advise you, but still. Yes.
Good.
List number 2 for pronouncement of judgment. Seal number 1, writ appeal 1175 of 2024.
I appear for the respondent.
Writ appeal 1175 of 2024. The order of the learned single judge is well reasoned. No ground has been made out for interference. The appeal is without merit and is accordingly dismissed. This court by interim order dated 8/8/24 directed that the results of the election to the post of treasurer shall not be declared without permission of the court. In view of the dismissal of the writ appeal, the election authorities are directed to announce the results of the election to the post of treasurer within 1 week from the date of service of this order.
Seal number 2, writ appeal 1673 of 2024.
Writ appeal 1673 of 2024. Writ appeal is allowed. The judgment and order in WP 5/666 of 2018 is set aside. The appellant is held to be eligible for the post of assistant accounts officer under the reservation for persons with disabilities. Respondents are directed to appoint the appellant to the post of the Assistant Accounts Officer. The appellant is entitled to notional seniority as per the final list published pursuant to the notification dated 8/9/2016. The process of including the appellant's name in the final selection list, issue of appointment order, and determining the seniority list shall be completed within 8 weeks from the date of this order.
Seal number 3, review petition 509 of 2024.
Review petition 509 of 2024. Review petition is dismissed. In view of the dismissal of review petition, the respondent state is directed to pay the compensation to the petitioner within a period of 6 weeks from the date of this order.
So list 1, the content matter, seal number 1.
My lords, kindly, my lords. Lords, the order dated, my lords, 10th of January 2024 at Annexure A, page 12, my lords. By the said order, my lords, the seniority list or the gradation list, my lords, dated 9/9/2015, that has been quashed, and the respondent authorities were directed to, my lords, redo the seniority list. Lords, the operative portion, my lords, is at page number 107. Lords, para number 84, my lords. As a result of the above, the gradation list of FDAs dated 9/9/2015 is quashed, and the BBMP is directed to redo the seniority list without applying the quota rule and assign seniority to the promotees from the date on which they were promoted. As far as the further promotions and the seniority list of in the promotional cadre of manager, which are the subject matter of writ petition 4296 of 2018 and writ petition 9778 of 2018 is concerned, it is to be stated that the petitioners therein were promoted as managers much prior to the directly recruited FDAs, and only by virtue of the refixation of the seniority of these directly recruited FDAs in the FDA cadre have they been given retrospective promotions from the date on which they became eligible to be promoted as managers. Since it has not been held that the seniority of the promotees FDAs is to be refixed from the date on which they were promoted, as their promotions were valid, the directly recruited FDAs will have to be placed below them, and they would thus not be entitled to claim seniority on the basis of the applicability of the quota rule. Consequently, the retrospective promotions granted to them under the order dated 10/7/2017 shall stand quashed. The promotion granted to them originally shall, however, subsist. By virtue of this order, my lords, the authorities were.
And there is no time limit.
Lords, there is no time frame. Lords, in fact, my lords, in the batch of lords, one of the writ petition lords, that is writ petition 1130 of 2020. Considering, lords, the very order, my lords disposed of the petition, lords, stating that the authorities will have to, the complainants, lords, will have to.
Very order was.
Lords, your lordships, lords, permitted the complainants therein, lords, to pursue, lords, complainant to put the authorities to time limit for complaints, and then, lords, thereafter, lords, we have also made representation, lords, in our case.
Where is that?
Lords, initially.
Did you set down the time limit in the representation?
Yes, lords.
Where is that?
Lords, may I just pass on?
No, it is not on the record.
Lords, it is not on the record. The original, lords, representation was part of, lords, the record. That is at page number 189. After that, lords, we have made one more. I'm sorry, my lords, I could not provide, my lords. I got the.
Learned advocate Mr. So-and-so places in the record by filing memo 2/5/25. Representation dated.
We have fixed, my lords, 4 weeks time.
5/15/125.
Please.
Whereby the authorities were put to time limit of 4 weeks to comply with the Directions of learned single judge which are subject matter of this contempt petition. The memo along with the copy of the representation is taken on the record. Paragraph notice returnable on 15th June.
Grateful.
Seal number 2. Ankit, just ready.
For the petitioner.
What is
The order is dated 26th of July 2024, my lords. The operative portion is at page number 20. My lords, the earlier writ petition was filed with a prayer for seeking mandamus, wherein the pension of the petitioner was not released due to a form that has not been forwarded by the respondent. Now, my lords, subsequent to which the learned single judge had allowed the writ petition with two directions. The operative portion at page number 20, please, my lords. A, the petition is disposed of, permitting the petitioner to take possession of his belongings from the first respondent's office without prejudice to his rights to work out such remedies that would be available to him with the proper forum. This has been complied with. However, it's the operative portion B, please, my lords.
notice?
The
Notice written 17th June. Follow.
So PL matter, seal number 3. Mudulavi.
My lord, I appear for the respondents. My lord, I apologize. My lord, there was a miscommunication. My lord, the
Yes.
FIRs along with the English translation I'm producing now. My lord, the petitioners have filed a reply to our compliance affidavit. May I please request my lord to have it on the reopening day, my lord, since the learned advocate. My lord, in case if there is some,
We have no objection, but
very well, then very well, my
this
lord.
can be disposed of beyond vacation, then reopen.
No, and then I leave it to my lord. My lord, with regard to, my lord, section 109, my lord, in the second FIR, if my lord were to take it at page 20,
What is this?
Reply along with citations. My lords, they're filing written reply to their complaint.
my lord, that's the reason why I requested my lord to have this on the 4th.
Today now we are filing.
Lords,
You don't have any urgency now?
it may be posted after vacation, my lords.
Bye.
Very good. Learned advocate Miss so and so and so on behalf of the
Given us the citation.
petitioner. Learned so and so appearing for Learned Senior Commissioner Aditya Sondhi. Files reply to the compliance affidavit dated 24/4/25 filed by the respondent, which is taken on record.
Any additional authorities.
On the other end, learned additional government advocate Srimati Nilofer Akbar files English translation of the FIR as required by the court. The same is also taken on record. Learned advocate for the petitioner stated, submitted paragraph that the petition may be posted after
Vacation.
vacation. As for the request, stand or to. Fifth of June.
Obliged, my lord.
These. Please, my lords.
On that day will. Where is your senior?
He's held up before the Supreme Court, my lords.
Then there is no urgency, then you just make us run after the matter, then no urgency.
My lords, there is an emergency.
Incident of shootout is concerned.
My lords,
Further submissions in that. So please say that. Has submitted their file. This separated by the steps of the counter is concerned.
What is the rate?
So it is in order to be uploaded. Submissions.
While filing the reply as above, it was submitted on behalf of the petitioner that while undertaking the investigation of the incident, the respondent investigating authorities shall strictly abide by the directions of the Supreme Court in that common cause so and so, so and so. Then on the other hand, learned so and so submits the copy, translated copy of the again will require. In that view, and as requested by learned petitioner, stand over to 5th of June.
Obliged, ma'am.
In the above view and as requested by learned of the petitioner, stand over to 5th of June.
please, my lords.
Hold on.
So nothing remains conveyed to your.
My lords,
Hold on,
direction to
5-6.
register FIR for culpable homicide is the prayer we've asked.
Pardon?
We've asked the direction, we've prayed for a direction from this court to register an FIR for culpable homicide. That's our main
We are
prayer.
aware of, we are aware of.
So if that
My
may
lord,
be
it has been
considered today, my
registered.
lords.
So we reserve for orders. You can reserve it for orders.
My lord, that has been revoked, my lord, section 109 in the second FIR. At page 20.
Advocate General is not here.
No, my lord.
Page 20.
Let it go on 5th, we'll take a call what to do.
Please.
We're not reserving the order.
Please, my
Obliged.
lords. Please, my lords.
So rate appeal matters, still number 4, so state appeal.
5th. Send out to 5th. So yes, for further consideration. For further consideration.
Number 4,
State appeal, my lords. There's a delay. Connected matters have been posted by my lordships on 4th of June, my lords.
Notice written, heard learned additional government advocate. Naveen Chandrasekhar, notice written on 4th of June.
this is commercial appeal, see number 5, Mr. R. Kiran.
For the appellant, my lord, this is a commercial appeal, my lord. The appeal is mainly on the 3 grounds. Before going to the grounds, my lord, there is a delay of 194 days. The grounds, my lord, is that
There is a delay, so we'll issue notice.
lordship also may permit me to serve on the council representing before the trial court. The matter is before the trial court tomorrow.
Mr. R. Kiran,
R. Kiran.
heard learned advocate R. Kiran for the appellant. There shall be notice. I speak both in appeal and.
Yeah, please,
delay.
on the
In delay condemnation application as well as in appeal. Returnable on.
Immediately
19th.
after the vacation, my lord, immediately after the vacations,
19th June,
please, my lord.
19th June.
And also permission to serve on the,
In addition to normal mode of service, learned counsel is permitted, for the appellant is permitted to serve copies to learned advocate who appeared in the court below
in the court.
on behalf of the original plaintiff.
Please. Oblige.
This, see number 6,
My lord,
PL.
this
please, your lord.
pertains to Constitution of the Civil Services Board. My lord, a meeting had been held on 23rd April, my lord, but due to want of quorum, My lord, a decision could not be taken. My lord, the meeting is now postponed to 14/5. If my lord could have it immediately after vacation, my lord, I will, this is the communication.
Now we'll take, next time we'll not spare you.
No, my lord, it's for this.
Civil process should be shown.
My lord, I'll see to it, my lord.
Because we are indirectly committing this disregard of the,
My lord, that I have conveyed, my lord. It's for that reason this letter also has been.
not you,
sent.
also we,
My lord, that's this what was conveyed to the government.
in granting time every time.
Can I
Yes.
renew my request? It's not adversarial, but in the meantime, my lords, let them not effect transfers without your lordship's permission. my lords.
My lord, may I have
The
this on the
process has
reopening, my
started.
lord. I'm not asking for a long date.
No, that's a-
Immediately on the reopening, my lord may have this and then. we
Till
will-
then, my lords, let them not affect transfers.
No, no.
Because there are already transfers which are affected. If they are, my lords, constituting anyway, let their fresh transfers take place after the board is constituted. Now, my lords, that they are serious about constituting and the meeting is convened, let them effect transfers after the board is constituted, my lords, for this year. That's my only request, my
It
lords.
is to be recollected that in this public interest petition, prayer is made to direct the respondents to constitute civil service board and fix the minimum tenure of the service to the service of the civil servants as per the judgment of the Supreme Court in TSR Subramanian versus Union of India, which was read petition and it is civil number 82 of 2011, decided on 31st October 2013. Full stop. The record witnesses that despite long time, comma, no material progress is shown by the respondent state in the direction of compliance with the directions of the apex court. Full stop. Some order was also passed. Order was also on
Yes.
28 period 8/2024. The court had an occasion to pass the order, observing that the inaction amounts to contumacious conduct on part of the state government, as it is a matter of, as it is a question of compliance of the directions of Honorable the Supreme Court to constitute the Civil Services Board. Today, when the petition came up for consideration, learned additional government advocate Timothy Nilofer were submitted. That the meeting was already held on
My lord, it was on 23/4. Now it is adjourned to 15.
23/4/24.
Now it's adjourned to 14/5/25.
in the process, however, due to want of quorum, it has to be adjourned to 14th of May,
14/5 this month, my lord.
2025. Full stop. Learned additional government was submitted that she will report to the court the progress about the meeting scheduled to be held on 14th May 2025. Very good. Stendo to 4th of
Yes, obliged.
4th of June, with an observation that court may have to take expecting that the state respondent shall become live to implement the order of the Supreme Court. Let us see. Otherwise, we are not saying to our next, but it implies.
My lord, I'll see to it, my lord.
In the meantime, very well.
Should we reject it? Do we reject it?
I understand, my lords. I understand what you said. Complete. Very well.
Obliged. my lord.
Would also be unemployed, my lord, if the transfers were. I would also be unemployed if the transfers were stopped, my lord.
Why?
Because half the litigation before the tribunal is only because of transfers. On a light, grateful.
Some matters are delicate in terms of dealing with it,
Very
in terms of defending also.
good.
Seal number 7, Mr. Uday Prakash, commercial appeal.
I appear for respondent, my lord. Kindly permit me
Appeal,
to
my
file
lord.
a objection on IA number 2.
What is it? This can go after it.
My lord,
Any urgency.
execution is already filed, my lord. That's the reason why I'm seeking intelligence, my lord.
So you are dependent.
I'm the defendant, my lord. The challenge is on 2 grounds, my lord. What had happened, written statement is filed before the trial court, commercial court, without a statement of truth, except a verification affidavit. The court accepts it and rejects it and passes a judgment, which this court, my lords, covered by judgment of this court, which says that it is a curable defect and an opportunity ought to have been given. That is one part, my lord. Another part,
You are supposed to pay the rent now, means profit.
mean profits.
Not
I'm
paid.
ordered to pay mean
Every
profits.
month is supposed to pay now.
Now the rentals are being paid is what my instructions are. But my friend said that there are some dues.
Deposit this 3 lakhs of rupees.
I will, very well. I will ask my clients immediately. Anyhow, it's a company, so I can.
If heard learned advocate Mr. Uday Prakash.
Please.
M for the appellant and learned advocate Mr.
Respondent.
So and so the respondent. This commercial appeal arises out of judgment and decree dated 27th November 2024, asked by the learned commercial court Udupi, decided over by learned district and session judge Udupi in commercial original suit number 61 of 24. In the facts of the case, the appeal is admitted, to be listed next on 20th August.
Very well.
Full stop. By way of interim relief, the impugned judgment decree shall remain stayed on condition,
Kindly see.
however, that the appellant deposits the amount of mean profit as well, and the amount of mean profit of rupees 3,02,000,
Please.
as well as the amount of rupees 1 lakh. It is towards what?
Per month, 1 lakh rupees.
Udupi court. No, 1 lakh is towards what?
Per month. That's
damages,
mean profits, damages in the form of mean profits.
Also.
Please.
So totaling 4,02,000.
Your lordship kindly see.
Per
3
month,
lakhs
my lord.
Plus every month is 1 lakh, your lordship. The lease is expired on.
Further continue to pay rupees 1
Yes.
lakh every month
Very
as
well.
directed by the court below. The amount of rupees 3,22,000 being the arrears of means profit shall be deposited within 6 weeks from now.
Please. Grateful. Obliged.
Post we are not.
Short date may be kindly. Because is the tenant already is admitted on the return statement also. Lease is already expired 1 year, my lord.
25th July.
Very well. Grateful.
Seal number 8, Mr. Rohan.
I beg to appear for the accused. My lord, against the order of the learned single judge, board has prepared a writ appeal. Board has prepared the writ appeal. I may permit it.
Writ appeal is filed.
Yes, my lord.
When it is coming up?
30th June, my lords. 30th of
And
June.
advocate Mrs. So and so, the respondent stated that the writ appeal number.
1549 of 2024. I'll just wait.
What is this? What is this? Writ appeal is filed against the judgment and order, against the order brought under the contempt jurisdiction, which is likely to be posted on 30th, which is going to be posted on 30th June.
Yes, my lord.
Also, this application, this contempt petition will be listed along with.
Very well, my lord.
Same date.
Great.
This is seal number 9, Mr. Anumantraya CH.
So necessary steps will be taken. within 4 weeks.
We have taken necessary steps, my lords. The respondent number 1 has denied to accept the notice. We tried serving notice upon him. He has denied.
File your affidavit.
Affidavit, because
In the
till
register.
29th evening we tried, and we had filed on 29th evening, we filed a memo before this honorable court. Today, affidavit, if your honest, if your lordship permits, the affidavit is ready.
Affidavit of
The nephew who had tried to serve.
file in the register.
And so the reason, yes, my lords, the
Yes.
reason for urgency in this matter is, my lords, this is a matter where the accused, the appellants were convicted of 302 offense. It was,
That time limit.
yes, my lords, 302 offense.
When it is expiring. We were not serving, what can be done?
My lords, we tried to serve, but he denied. But through WhatsApp we had served. He has invariably accepted the notice, but he has not come on record. It is not on record.
What happened to hand summons?
And summons. And summons. It was served through WhatsApp also. It was.
WhatsApp is a permissible means?
No, it is not permissible. It is not permissible. If he denies, it is as good as being served.
You are responsible for not serving in a proper mode, with a proper mode.
Hand summons was given. We had been to his house. The house is demolished now.
Immediately file affidavit that they are not accepting.
It's
File it now. Now, when it is expiring, your time period.
you know, my lords, what has happened here? He was convicted of 302, confirmed by this honorable court. Then the honorable governor was pleased to commute the sentence to the sentence already served. Then the same was challenged before the single judge.
Who challenged? State?
No, my lords, the victim, victim.
But sentence was commuted.
My lords.
Sentence was reduced.
Yes, my lords. It was commuted by the governor to the already sentence served. So it was set. The order of the governor was set aside by the single judge, and they were taken back again to the custody because the commutation was set aside by the single judge. Now we have challenged that order of the single judge because, my lords, a para may be looked into, my lords, of the single judge. The single judge opines that because the governor could not have passed that order because they have not completed 14 years as required under 433A. My lords, for exercising Article 161, that compliance is not necessary. 433, Section 433 is independent and Article 161 is independent.
Now, what is the urgency? Will keep after vacation.
Yes, my lord. The reason is, my lords, before the order was passed, the appellant was in custody for the past 12 years. During that period, he had not got married, and because he was released on commutation recently, before 6 months before he got married. So only that reason he has taken into custody, and his marital life is also at stake, man. So that is the only reason I am pressing for stay, man. It's nothing else.
You were saying some period was expiring.
No, man.
Then you all throughout mentioned like that and got it listed. Some period of investigation was expiring.
No,
No.
not.
So then let it be posted after immediately on vacation.
A para may be looked into in the single judge order. A para may be looked into in the single bench order, my lords, in the judgment of the single judge. The single judge order, para may be looked into. Para 50, my lords. At page 52 of the memorandum of appeal.
50.
Page 52 of the memorandum of appeal.
Correct.
And page 35 of the single bench order. Para 50, my lords. At the last para. I have no hesitation to hold that respondent number 1 and respondent number 2, being accused number 1 and 3, who are convicted for the offence under section 302 of IPC for having caused double murder of both parents of the petitioner and sentenced to serve life imprisonment, were not entitled for remission even by exercising the power under Article 161 of the Constitution of India before completion of 14 years of sentence without remission, as it is in violation of the even rules framed by the state. Article 161 cannot be restricted by any rules. It is the decision held by the Honorable Apex Court that
Now
Article
we'll
1.
take up after vacation. What is the urgency that? can bid
Agency,
for
they're in
court?
custody. They're in custody.
Huh?
They're in custody. The appellants are in custody.
In custody?
Custody. I may be permitted to place the decision of the apex court. If I may place the judgment of the apex court. Will not interfere.
You want the initial release to be stayed.
The order of the single judge.
It's not there in the set.
Yeah, yes, what is yours?
Lord, sir.
It was 302 offense.
Very much,
He
my
was
lord.
convicted for life.
The set is not complete, my lords. It's not tallying with the submissions made. The set served on the government is not complete, my lord.
That's it now. Serve notice. The state had supported the case of the appellants before the single judge because it was their order which was set aside.
Which prayer is not granted? Prayer for quashing the order dated 28/16 is rejected. What is that order?
My lords, the first prayer is that was the setting aside the order of commutation. The second one that also challenged the notification where the state had given guidelines to consider for commutation. That is for considering commutation for section.
Where is this order? Where is this order?
My lords, in the additional documents filed on 17/1/25.
In this compilation, it is
In
there.
the compilation, it is there.
Tell the page.
Page 71, my lords.
That is okay. Translation is not there.
Translation copy I filed in additional documents.
Very good.
Filed on 17/1/25. At page 15.
When it is filed?
17/1/25 minutes.
17/1.
translated copy at page 15.
Learned additional government advocate, Mr. Naveen Chandrasekhar submitted that he is not given the complete set of papers
Just now it was said.
and that it is given only in course of the conducting of the matter today. Therefore, we requested for time post on the other end learned paragraph, on the other end learned advocate. So and so and so. Rest for the urgency, stating that the appellant is in custody. But remission is not approved.
It is approved, my lords.
No, learned single said that there is no power to remit as far as 302 is concerned.
It's a question of computation, my lords. One more month.
No, my lords.
My lords
I'll-
may hear it immediately after vacation, my lords.
I'll explain, my lords. In 302 also, it can be given by the governor, my
We'll
lords.
see.
This judgment would. One part of this judgment would clear the possession. Para 25 my lords. At para 25 my lords.
There are
25 minutes on the last page. It is a case of 302 only. Para 25. The prisoner herein has completed 12 years and 25 days as on 6/7/21 as per the custody certificate produced by the state. The case for the premature release of the prisoner in terms of policy of the state government dated 13/8/2008, the policy which was applicable on the date of his conviction can be considered only after he completes 14 years of actual imprisonment. Not in this case, it is not so. This is exercised under Article 161. The next para. However, the state government can consider the prisoner in question for premature release after undergoing imprisonment for less than 14 years only under Article 161. In this, my lords, at page 16 of the document given on 17/1/25, the order of the state, it was exercised under Article 161 upon the approval of the governor. At the bottom.
your client has undergone how much period of imprisonment?
Yes, my lords. It is the same can be gathered from the same compilation at page 31, my lords. Relevant page 33.
Tell us.
My lord, one is Siddharaju, the appellant number 2, and Parmish, appellant number 1.
How much period you underwent?
My lords, the appellant number 2 has undergone 12 years, 15 days without remission, and appellant number 1 has undergone 12 years, 11 days without remission. And
where is that?
at page 33, my lords.
There is nothing. Page 33 of the order.
No, my lords. Page 33 of the compilation, 17/1/25, filed on 17/1/25.
Where is that compilation? The style of you change your style. We'll change this style. This is absolutely unscientific way of filing the papers and giving the numbers, and not possible for you to find out this.
IA number,
IA number 3 of 25,
3 of 25. Page number is
page 33.
Some security like a suspension. So we can be for some conditions and we will take.
Serial number 1 is of appellant number 2, Sidraju. Serial number 1, Sidraju.
Serial number, there is no serial number. Which page? Where is the name? So how many?
My lords,
Only one appellant is there.
2 appellants, my lords.
2 appellants.
Yes, my lords. Arising from the same crime. Parmesh and Sidraju, appellant number 2.
So both were under same FIR.
Same crime.
302.
302 read with 34.
And this Parmesh was given remission on which?
Both of them, both Sidraju and Parmesh were given commutation.
When?
On 31/8/2018.
They were given remission under
Commutation under section under Article 161.
161. Commutation of sentence.
Commutation of sentence.
What was the sentence? Life imprisonment.
Life imprisonment.
Both on the same date.
Both on the same date.
Then what happened?
Then the order of that commutation was challenged before the single judge.
What does single judge say?
Single judge says that the governor could not have exercised the same because it was in violation of the rules framed by the state. And the apex court says that Article 161 cannot be restricted by any of that
rules. This petition was filed by only you, one of them?
The victim filed the petition, the son of the deceased, both the deceased.
Then you are party in the petition?
Yes, my lords, party in the petition. Respond number 1
Where
and
is that? Ah. The kin of the victim. Who died out of commission of offense under section 302 of the Indian Penal Code 1860. Filed a writ petition. Seeking to challenge order dated 31/8/2018. Passed by respondent number 3. The state, that's the state, whereby original respondent 1 and 2, original respondent numbers 1 and 2, dash appellant's hearing came to be premature, came to be released prematurely, came to be granted the benefit of premature release. Full stop. They were the accused convicted for the offense in question and undergoing the life imprisonment, undergoing the sentence of life imprisonment. Full stop. The ground was that the ground of challenge to the order of release was premature release was that even though they had not completed actual imprisonment of 14 years, comma, the premature relief was granted. Paragraph 11, a single judge allowed the petition in part, ordered it at 31/8/18 of the state government, respondent 3 hearing came to be set aside, which pertain to the premature release of respondent 1 and 2. Full stop. The full stop. 11, a single judge refused to quash, ordered it at 23/8/16. Passed by respondent 3. Full stop. Respondent 1 and 2, thus the appellants herein were directed to surrender before the jurisdictional magistrate within a period of 4 weeks from today. 4 weeks from the date of the order, from the date of service of the summons, from the date of the period of 4 weeks to serve the remaining sentence. The ground it was submitted by learned advocate for petitioner Mr. So and so that the ground weighed with learned single judge in passing the aforesaid order was that the governor could not have exercised the power under under Article 161 of the Constitution to remit the grant the remission.
To commute. To commute.
Commutation, remission, what is it? What is the word?
Commutation.
Commutation of sentence. Full stop. On the other hand, learned additional government advocate Navin Chandra Sekhar justified the order. Full stop. In state of Haryana and others versus Rajkumar, the Supreme Court observed as under. In paragraph, Supreme Court dealt with the aspect of power of appropriate government to suspend, remit, and commute sentences, and the manner of exercising the same. It also dealt with the nature and scope of power of Article 161 to be exercised by the governor. Summarizing the principle, comma, it was observed paragraph. Summarizing the principles on the issue, summarizing the principles in that regard, comma, the Supreme Court observed as under in paragraph 25. Quote this bracketed paragraph. The prima facie case is made out. Against the prima facie case is made out in respect of the the prima facie case is made out to challenge the judgment and order on a single judge, which has taken a contrary view, holding that the governor could not exercise the powers under Article 161 of the Constitution to commute the sentence. Full stop. The ultimate analysis, full stop. In the ultimate analysis, the issue is, the question is of liberty of the personal liberty of the personal liberty of the appellants. Full stop. In the facts of the case, the appeal is admitted. It shall be listed next on 28th of July. The impugned judgment and the directions in the impugned, the directions, the appellants are directed to be released by way of interim relief. The appellants are directed to be released on following condition. Both the appellants shall furnish a bond,
surety,
solvent security to the of the amount of rupees. Surety.
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 Solvent surety.
Of rupees 2 lakhs each.
2 lakhs each.
2. Either of the appellant accused shall not leave the territorial borders of the state of Karnataka. 3, while traveling within the state of Karnataka, wherever the appellants go, they should inform the jurisdictional police station about their stay and the address in that area. Full stop. 3, the appellant shall not indulge into any unlawful activity while enjoying the personal liberty.
Much obliged.
The release shall be effected forthwith on compliance of the furnishing of
PF.
surety as directed. Surety and 2 lakhs before the trial court.
Sessions Court, that is Additional Session Judge FTSE Hassan.
Before the Court of Learned Additional Session Judge Hassan.
Additional Session Judge FTSE Hassan.
This 161 is independent of power of the state government.
Yes, my lords. Much obliged.
Delay condom.
Liberty.
The
Personal
beginning,
liberty
delay
of
how many days?
41 days.
In the facts of the case and having heard learned advocates for the respective parties, the delay of 41 days is. Who is private respondent?
My lords.
Complaint. Starting heard learned so for the applicant and learned additional government advocates in this application for delay condemnation. Since responder one is yet to be has not been appearing, there shall be notice. 2, he said respondent returnable on when it is kept.
20th of July.
28th of July.
28th of July.
28th of
28th
July.
of July. 28th of July. Full stop. In the facts of the case, since the ultimate question involved is about the personal liberty of the appellant's hearing, whose sentence was commuted in exercise of powers under Article 161 of the Constitution, but learned single judge has set aside the said order. The court decided to take up the appeal at this stage to prima facie examine the merits of the impugned order of learned single judge, then entire order.
Much. My lords, if I'm not taking advantage of the situation, hand delivery of the order.
We keep it little earlier instead of 28th April, July, 21st July, 7th July. And delivery you want? Someone's band delivery?
No, the order, today's order.
Copy of this order shall be forwarded by the registry forthwith to the jail authorities.
Jail
concerned.
authorities.
Also, learned additional government advocate shall also inform the jail authorities about the above
Mysore.
order, for which purpose the copy shall be made available to learned additional government also for its onward communication.
Much obliged.
Office objection for first time, seal number 10, it's a state appeal.
We should take compliance within 4 weeks, my lord.
It may not be necessary. Matter has become infructuous, my lord. At least you can appoint Mari. You have already appointed administrator. Copy. Matter has become infructuous. The committee of the respondent temple, the term was to expire on 21/3/25. But Karga was already started. That function had already started. Therefore, learned single judge had directed that committee should be continued up to 15/4/2025. That is the order that is challenged in this appeal. After 15/4, they have already appointed the administrator in the place of our committee.
As per
Sorry,
the
my lord, I have only one copy of the order.
as
Just
per
place
the
it on record. It's
order
in Kannada.
dated
It's in Kannada.
1/4/25, learned single judge, which was passed in the pending proceedings of the writ petition, learned single judge inter-alia provided that provided that that Sri Dharmaraya Swami Temple Karaga Mahotsav Committee shall continue to exist till 15/4/25 by extending the term of the committee up to the said date. It was stated paragraph when the appeal came up for consideration today that not only the said order is worked out for itself.
I've given the copy, my lord. It's in Kannada. I'm sorry, my lord. I will furnish translation.
The competent authority has now appointed administrator to the temple committee
Please.
to manage the temple committee
With effect from 17/4.
with effect from 17/4/25. In view of the above subsequent development, the present appeal stands infructuous, without going into the merits thereof. Merits of the case of the either side, it is disposed of accordingly.
This is seal number 11,
Then this one do copy.
it's Amit Deshpande.
Government nimbu.
Objection.
My lord, the office objection is only that, my lord, the affidavit which is of the complainant. My lord, she is an American citizen. My lord, I have filed an affidavit stating that I am representing her, and my lord, the affidavit would be filed. That is the only objection, my lord. And my lord, so far as the impugned order, my lord, the order of breach of the order is at page 15. My lord, 4 weeks time was granted to comply, my lord. It has lapsed, my lord.
These objections are dispensed with. Notice returnable on 17th
Very well.
June.
My lord, I may be permitted to.
Translation you file.
My lord, the annexure B, my lord, there we are not placing reliance on it. It's only for a reference.
We'll see if the translation copy is required, it may be supplied in subsequent step.
Yes.
If required by the court, then.
Very well.
Announcement ಆಯ್ತಲ್ಲ?
ಲಿಸ್ಟ್ ಟು ಸೀರಿಯಲ್ ನಂಬರ್ ಅದು ಏನಾಯ್ತು ಹಲೋ ಏನಾಯ್ತು ಟೂ ಅಲ್ಲ ಸೀರಿಯಲ್ ನಂಬರ್ 2 ಲಿಸ್ಟ್ 2 ಸ್ವರೂಪ
ಸರ್ ನೀವು ಎಷ್ಟು ಫೈಲ್
ಮೂರೇ ಒಂದು ರಿಟ್ ಅಪೀಲ್ ದೊಡ್ಡದು ಅದು ಅದು ಕೊಯ್ ಶೀಟ್ ಹಾಕ್ಬಿಡ್ಬೇಕು. ಇದು ಅಪೇರೆನ್ಸ್ ಇದು ಅಪೇರೆನ್ಸ್ ಹಾಕ್ಬಿಡ್ಬೇಕು.
ಇದು ಮೂರು
ಎರಡು ಅಪೇರೆನ್ಸ್ ಹಾಕ್ಬೇಕು. ಅದು ಅಪೇರೆನ್ಸ್ ಅದರಲ್ಲಿ ಮೇಡಮ್ ಮೇಡಮ್ ವೆಕೇಶನ್
ಟೇಕ್ ನೋಟಿಸ್ ಆಗಿತ್ತು ಅವರು ಡೆಸಿಗ್ನೇಟೆಡ್ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಅಲ್ವಾ ಯಾರು ಆಗ್ತಿಲ್ಲ. ಟೇಕ್ ನೋಟಿಸ್ ಆಗಿತ್ತು ಬಟ್ ನಾನು ಫೋನ್ ಮಾಡಿದ್ದೆ ಏನೋ ಅಲ್ಲಿಂದ ಬೋರ್ಡ್ ಇಂದ ಏನೋ ನಮ್ಗೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಕೊಡ್ತಾರೆ ಅದಕ್ಕೆ ನಾವು ಅಪ್ಡೇಟ್ ಆಗ್ತಿಲ್ಲ. ಅದಾಗಿ ಒಟ್ಟಲ್ಲಿ ವಕಾಲತ್ ನಾಟಕ ಇದ್ದು ನನ್ನ ಹೆಸರು ತೋರಿಸ್ಬಿಟ್ಟು ಅಕ್ಸೆಪ್ಟ್ ನೋಟಿಸು ಇಷ್ಟ ಆಯ್ತು. ಅವರು ಬೋರ್ಡ್ ಅವರು ಯಾರಿಗೂ ಕೊಟ್ಟಿಲ್ಲ. ಅದಕ್ಕೆ ಪ್ರಶಾಂತ್ ಅದು ಫೈಲು
ಸರ್ ಕಾಲೇಜ್ ಹತ್ರ ಹೋಗ್ಬೇಕು ಅಂತ ಕಳಿಸ್ಬಿಟ್ಟು ಬರ್ತೀನಿ. ಇಲ್ಲ ಅದು ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ಮ್ ಎಲ್ಲ ತಗೊಂಡು ಹೋಗ್ಬೇಕು ಅದಕ್ಕೆ ಕರೆಸ್ತೇವೆ ಅವನ ಕೆಲಸ ಅವನೇ ಹೋಗಿ ಬರ್ತಾನೆ. ಇಲ್ಲ ಇವತ್ತೇನೆ ಬರ್ತೀವಿ. ನಮಗೆ ಉಸಿರಾಡಕ್ಕೆ ಟೈಮ್ ಸಿಗ್ತಾ ಇಲ್ಲ. ಕೊಡ್ತೀನಿ ಎಲ್ಲ ಕೊಡ್ತೀನಿ.
ಫೋಟೋ ತೆಗಿತಾರೆ ಸರ್, ಫೋಟೋ ಮತ್ತೆ ಗೊತ್ತಲ್ಲ ನಿಮ್ಗೆ, ಫೋಟೋ ಡಿಲೀಟ್ ಮಾಡಿ, ಫೋಟೋ ತೆಗಿತಾರೆ, ಫೋಟೋ ತೆಗಿಬಾರ್ದು. ಸೋಷಿಯಲ್ ಮೀಡಿಯಾ ನಾವು ರೆಸ್ಪಾನ್ಸಿಬಲ್ ಆಗ್ತೀವಿ, ಗೊತ್ತಲ್ಲ ಸರ್.
ಸೆಕೆಂಡ್ ಸೆಟ್ ದಿಕ್ಕದು ಇವರು